Hi, this is Whitney with another short video on protective orders. Protective orders in Virginia are usually issued when someone has a reasonable apprehension of bodily injury, harm, or sexual assault. Those items have to be proven in order for a protective order to be issued. There are three different types of protective orders in Virginia. The first is an emergency protective order. It is usually issued by a magistrate. A person goes to the magistrate's office in their locality and swears out an affidavit, tells them what's going on, and the magistrate determines whether or not it's appropriate to issue an emergency protective order. These protective orders only last usually for 72 hours or until the courts open if it's a holiday season. Just keep that in mind. The important thing though is you do have an expiration date on that emergency protective order. If you want it extended, you need to go file with the court for a preliminary protective order. Now, if you are a family or household member, or you're related in some way, then you need to go to juvenile and domestic relations court to extend it. If you're not related in any way, or not a household member, then you go to general district court to extend it. When this happens, when you apply or ask for a preliminary protective order, you would typically go in front of the judge. It's what's called an ex parte proceeding. It is just where one party is in front of the judge making certain allegations. The judge determines at that point whether it's appropriate to extend it or grant a preliminary protective order. If they do, they usually set a hearing in about 2 to 3 weeks for a permanent protective order hearing. And at that hearing, both parties are present, both parties present their evidence, and then the judge decides whether or not it's appropriate to issue a permanent protective order, which can last up to 2 years. These are important to your family law case, of course, if there are issues of family abuse or domestic violence. If you were the victim, of course, I encourage you to consider this option, one, to protect yourself. I know it's just, some people think it's a piece of paper, but at least provide some security to you should you need it. And the other is, it does help your case. It strengthens, it shows a pattern of behavior that was cruel and harmful to you. If on the flip side though, you're defending against it, you really need to be cognizant of what was said, what was done, what did you say leading up to the protective order being issued. Did you make any threats verbally? Were you physically aggressive? Those are all things that we have to consider in determining whether a protective order is going to be issued. Little known facts about protective orders: they can grant someone possession of a home for a short period of time. They can provide that the other party does not have to turn off utilities such as water and electricity. They can give you possession of actually your pets too, which is kind of an interesting tweak that happened a few years ago. So protective orders can provide you with safety. They can also provide either no contact. They could provide that you can only be within a certain space for a certain amount of time or length or duration. They can also just provide no further acts of family harm to occur, which is basically saying, you keep to your corner, the other person keeps to their corner, and don't engage, and it's going to be fine. So there are many different types of protective orders. There's many different nuances to them. Judges can order many different things through protective orders. They can even do some custody arrangements, and they can even extend to children on a very temporary basis. So it's important, if you are seeking a protective order, to know what to ask for. And if you're defending against a protective order, it's important to know what elements have to be proven and how we best can defend your case. I have handled protective orders now for several years. I have both defended and helped victims get protective orders. So I can certainly walk through your case, ask the pertinent questions, and be realistic about what you're facing and whether or not a protective order will or will not be issued. I will say that my biggest thing with protective orders is to be honest with your attorney. Even if you think it paints you in a bad light, even if you said something stupid and you wish you'd never said it and you didn't mean it in that moment. But if you've said it, you've texted it, posted it on Facebook, Instagram, Twitter, Snapchat, whatever it may be, it's going to be relevant at that hearing. And full disclosure to your attorney is better than someone being blindsided in the courtroom. And even if you think something's innocuous or funny or a joke, Usually when we get in the courtroom, that's not the way it's construed. And once you post or write or send something, it's harder to put context to it in the heat of the moment in the courtroom, as opposed to if you tell us beforehand, we can at least think through how to mitigate the damage that may cause to your case. As always, if you have any questions or you feel like I can help you and the Pennington Law Firm would be a great choice for you, please feel free to reach out to me at 276-477-1422. And like I always say, we look forward to seeing you soon.